We got new standards. Dana's here too.
Welcome to the August 20th meeting of the Calaveras County Planning Commission. Please stand as the line is
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Let the record show that all commissioners and staff are present. Are there any agenda changes? Thank you. We are at item C, public comment period. If there's anyone here who would like to discuss briefly a land use issue that is not on today's agenda, please step forward to the podium, state your name, and sign in, please. Seeing no one rushing up, we'll move on to our consent agenda. Approval of the minutes from the August 6, 2009 Planning Commission meeting. Are there any additions or corrections? If not, motion would be in order. All in favor? Abstain? Minutes passed. 4-1. I'd like to announce that at the last meeting of the Planning Commission, the Commission met in closed session regarding anticipated litigation and discussed the appeals by Names regarding Trinitas, also by Ellen Burke, Hoffman and Johnson, and the appeal submitted by John Buckley on behalf of CSAC. There was no action taken as a result of that closed session. Item E, public hearing, 2004-114 naming. 3 appeals of staff determinations relative to interpretation of Calaveras County zoning code regarding the Ridge at Trinitas golf course facilities at 9209 Hospital Road, Valley Springs, continue from July 16, 2009. As a follow-up to the denial of the application from Michael and Michelle Mamie for a zoning amendment, tentative subdivision tract map, conditional use permit, and administrative use permit for the subject property, interim community development director Brent Harrington issued a letter to the applicants on May 15, 2009, explaining the impact of that decision on the applicant's property, aka the Ridge at Trinitas, and uses permitted under the existing general plan land use designation, natural resource land, agricultural preserve, and county zoning code section 17.18 agricultural preserve. The property is located on the east side of Hospital Road, approximately 1.5 miles north of State Highway 26 and 3 miles south of State Highway 12. Assessor parcel numbers 050-052-041 and 050-052-042 are portions of the north half of Section 12, a portion of the south half of the northeast quarter of Section 12, and the northwest quarter of the southeast quarter of Section 12, Township 3 North, Range 9 East, Mount Diablo Meridian. 3 appeals to staff's interpretation of those uses have been received, specifically as they relate to the following. Number 1, appeal by Ellen Burke, Hoffman and Johnson as legal counsel for and on behalf of Michael and Michelle Mamie regarding use of the golf course, golfing on the premises, and legally permitted uses on property with the zoning designation of agricultural preserve. Number Number 2, appeal by Mark V. Connolly as legal counsel for and on behalf of Keep It Rural Calaveras, PERC, regarding staff's interpretation that the use of the subject property is distinct from the physical aspects of the property, e.g. the golf course's landscaping. Use of the land for a golf course is allowed so long as no golfing occurs. Item 3, appeal by John Buckley, Executive Director, on behalf of Central Sierra Environmental Resource Center, CSERC, regarding staff's interpretation that A, the physical aspects of the golf course are considered to be landscaping, and that due to that interpretation, B, the county does not have the legal authority to require removal of the physical aspects of the golf course, so long as golfing on the course does not occur. Strategy. All right, prior to opening the public hearing, are there any comments from staff? No. All right. Comments from commissioners?
Yes, thank you. I wanted to respond to a comment that Mr. Russ made at the July 16th. Wanted to respond to a comment that Mr. Russ made at the July 16th Planning Commission, where he stated that I had a conflict of interest on the Trinitas golf course project. That was kind of a surprise to me, so I asked and investigated and found that he'd made similar claims to County Council as well as some of the Board of Supervisors. And I guess the inference is that, since I had referred to my notes during my comments at the conclusion of the public hearing, that I had, already made up my mind. So I just want to kind of clarify what my process was with that. And, as you all know, this is a extremely complex and detailed project. And we were submitted thousands of pages of documents, including draft and final EIRs, a lot of background information from experts, quite a bit of information, as well as, hours and hours of public testimony. I guess my process in order to, make sense of that and come to conclusions is I take notes, and my notes take notes. And as my note gathering takes place and I gather lots and lots of paper, I start consolidating those notes into issues and concerns that I have. And at the first public hearing, we were asked to state what some of them were, at least at that point in the juncture in the process, which I did. I continually to revise, my notes as we go along. I had consolidated those notes at prior to the final public hearing. And at that hearing, I didn't really hear any testimony that altered, the conclusions or the thoughts that I had gathered up to that point, or that has substantially changed my concerns regarding the project. So when making my comments in the summary of that public hearing, I referred to those. I went through the same process probably as all of you did in terms of the information that I considered, which was the evidence presented throughout the process. And so, don't believe I have a conflict of interest and continue to participate in the hearings and the process on this project.
Thank you. Any other comments from commissioners? All right, we'll discuss a little bit the procedure of the public hearing. We no longer swear in persons who want to testify, but of course we ask and expect that you will testify the truth as you know it. You can see there are a lot of people here, and many who probably wish to testify on one if not all of the appeals. So we will ask that all of you be as brief as possible, and if someone gets up and steals your thunder and says what you wanted to say, just state that you agree with the previous speaker. We want to give you all an opportunity to speak, but in the interest of time, we also want to be very vigilant about how we conduct the hearing. What we'll do is we'll take the appeals in the order in which they're listed. Initially, the appellant will, or his or her representative will will be allowed to speak first, followed by members of the public. The appellant will then have an opportunity to answer any questions that have been brought up, and then the public will have a final opportunity. So with that, we will open the public hearing and ask that representatives of Mr. and Mrs. Neme or the Nemes themselves, they would like to step forward. Please identify yourself, and we do have a sign-in sheet so that we can get the spelling of your name correct.
Good morning. My name is Christine Griffith. I'm an attorney with the law firm of Elmenberg, Kaufman & Johnson. And with me is my associate, Kern Calfee. Together we represent the Nemes in this project, and we have provided the earlier appeal letter. We also have with us today some additional correspondence that includes some exhibits and some information that we're going to refer to. And so we have copies of that for everyone. I don't know what the protocol is here.
As this information, would you like permission to read this prior to your presentation?
I think that it is, it's sort of a written description of many of the things that I'm going to say here today, and it also provides some backup documents to our correspondence, and that is actually quite short. I think it's a 3-page letter, just kind of summarizing our comments after having received the staff report. But you know, we wanted the commissioners to at least have the information that backs up what we're going to say today in front of you, so that you can refer to it if you choose. When I first met with staff on this project, and we haven't been involved in this project for that long, but when I first met with staff on this project, this proceeding today was described to me as the purpose of it was to really determine what was otherwise an open question, which is whether the golf uses on the Trinitas property are covered under this definition of agritourism, which I think is obviously that's central to our appeal letter that you received previously, and I think it's the central issue. I think that the staff report that you received and that we received is, in fact, a much more one-sided document. It doesn't actually sort of present two sides of an argument and say, well, we recommend X. It actually states it in a much more affirmative manner that, as far as staff is concerned, the golf is not permitted. But I did want to say that the original way that this was described to me was, gee, we're going to have a discussion about this open question as to whether golf is included in this definition. And so that's the perspective from which I'm approaching my comments to you today. There's a lot of history and there's a lot of documents in the record relating to my client's property and various projects that have come forward. But I think that the question presented today is actually a relatively straightforward one, and that is whether the golf uses are included in the county's definition of agritourism. And the definition, which is provided, obviously in the county code, unlike the way that it's described in the staff report, is not in fact a list of activities. The definition itself is that it includes activities that occur on land where there is agriculture that are designed for the entertainment and enjoyment of the people that are visiting and partaking in them, and that assist in, they enhance the economic viability of the agricultural activity. The purpose being that it being difficult to really make a living and sustain an agricultural operation in these modern times economically, the idea was that you would allow some other uses on agricultural lands in order to make the agricultural activity itself more economically viable. And so the county code is in fact a definition in those broad general terms, and then it says examples of agritourism enterprises include but are not limited to the following. So it is in no way described in the definition as an exclusive list of activities. I think that the staff report comes from the perspective of saying, well, there's an exclusive list, and so anything on that list is not part of the definition. And in fact, in the code itself, that's not the way it works. There's a broad definition, and then there's a list of possible examples that again, the language is very clear that it's not limited to the following activities. In addition, in the zoning section, where it says some activities are permitted without a conditional use permit, some activities require a conditional use permit, the trigger really has to do with how many people are participating at the time. So an activity with less than 75 people attending is permitted as a right. And so it doesn't, again, have an exclusive list of activities. The staff report also states that there's supposed to be some sort of a connection, a nexus between the agritourism activity and the agriculture that's occurring. And again, that doesn't appear in the definition, and in fact some of the specific examples that are provided have no reasonable nexus with farming, like cross-country skiing has sort of no reasonable nexus with any kind of agricultural activity. So that definition, again, that part of it is not actually in the code. It's just something that appears, I think, in the staff report, but it's not really supported by the language that's in there. Ultimately, when a body is called upon to determine the meaning of a particular piece of legislation or a particular code section, they will often look to, well, what was the history behind this provision? How was it created? What was the intent? And of course, with most county ordinances, there's usually not an official legislative history like there is with state or federal law. But what we do know with the Ag Coalition, who initially prepared this definition and set it forward, that their intent was clear that it's intended to be an open-ended definition, intentionally broad, because it was felt at the time that we couldn't possibly foresee all the many creative ways in which somebody could find that some recreational activity or some sort of visitor serving use would enhance the agricultural activities, and that they wanted to leave it open-ended for all possibilities. And then the sort of the limitation on that again in the code is, well, as long as it's not like a huge activity, then you don't need a permit. So if it involves less than 75 people at a time, then that's okay with us and you don't need a permit. Now, again, staff would have you believe in the report that golf was intentionally excluded, and there's absolutely no evidence of that whatsoever. Staff doesn't refer to any, and those that were involved in preparing this definition from the beginning refute that and say, in fact, quite the opposite. It was intentionally open-ended. At the time that the ordinance was adopted, there was a negative declaration that was prepared and adopted to examine the potential environmental impacts of this agritourism definition. And in fact, in that negative declaration, it says that the possible uses are so broad that we can't go through and enumerate every single one and analyze each one individually. We can only analyze it sort of as a broad category. Now, staff, again, in the staff report says, well, that negative declaration never mentioned golf. And so if we had meant golf, we would have said golf in that negative declaration. But in fact, there's not a single particular activity that is named in that document. It says that it supports the position that we're taking. In fact, it was very broad, and it was not a defined list of activities. So I think that that's an important point to consider. Now, another point that staff has raised in the report is that they could find no evidence anywhere that golf was included in any definition of agritourism, or that golf is considered in any other jurisdictions or anywhere to be agritourism. And I personally found that statement surprising in the staff report, because if I went on Google, as I did when we first got this project, and you type in golf and agritourism, you get all kinds of references, including the state's agritourism website. In fact, specifically mentions our client's property as an example of agritourism. And staff is aware of that. We've been told by the people that run that website that county planning staff contacted them some time ago and asked them to remove the House project from that website, and they declined. So it was surprising to me that the staff report says that they're not aware of anywhere where it says that golf is agritourism. And also the leading publication in the state of California on agritourism specifically lists golf as one of the possible activities. And there are other farms around that have golf activities on them. Again, like a simple search of the internet pops up all kinds of results where you have people on farms that are doing golf, and sometimes they use the specific term agritourism and sometimes they don't, but it's clear that there are many instances of this connection between agriculture and farms and golf activities. And I guess even recently in Calaveras County, there was somebody that was advertising cow pasture golf, which, haven't actually partaken in that activity myself, so I'm not exactly sure what it involves, but it certainly seems to involve a farm activity and golf activities together. In addition, a woman named Jane Eckert, who is considered a sort of national agritourism expert and who has previously been retained by Calaveras County to advise them as an expert consultant, maintains a national database of agritourism activities, and that database includes golf. So the idea of the notion that nowhere is golf connected with the term agritourism is completely false, and it's a very simple process to find the many places where it's mentioned, and we've provided many of those to you today. I'm going to move on to some different issues. For some time now, for I think approximately, 5 or 6 years, 5 years, the property has been designated by the county tax assessor as a commercial golf facility, has been taxed as a commercial golf facility, and has paid the increased property tax that would be associated with that different designation. I think that it's important for the county to take one position on these things, and even though the assessor is not the planning department, there is clearly a connection between requiring a property owner to pay a property tax at a rate for a certain activity on their land and permitting or not permitting that activity. To date, the county has collected approximately $250,000 as a result of this designation, which is obviously a benefit to the county that is an additional benefit above and beyond the visitors to the Trinitas property. Obviously, depending on how things turn out, that money might have to be returned at some point. But I do want everybody to be aware that that is another aspect of the county regulation that is addressing this issue. There's also been a lot of discussion in the staff report and elsewhere about whether or not the construction of the golf course at the time that it was originally constructed was lawful. And I think that one thing that's obscured the staff report is that staff was well aware, county staff was well aware of what was going on, participated actively in the discussions throughout the process. The chief enforcement officer at the time said that no permit was required for the physical work that was being done on the property. At the time, the county didn't have a grading ordinance. the grading ordinance that it has now. And it was very clear, the staff direction was very clear to my clients that they did not need, a grading permit, a building permit, or another permit to perform that physical activity on the site. What they did need was a stormwater permit, which they got. Even the planning director's initial letter of determination that we're appealing here today says that the construction of the golf course is at this point basically a moot issue, and that that staff at most would say now that, gee, maybe they disagree with the decision that was made at the time, but they can see that that was in fact the decision that was made. And staff has also conceded, in fact, again, in the first meeting that I had with staff, that the Nevies could use the golf course for personal use, which, that has to be based on an assumption that the golf course itself is there legally in the first place. Staff was so involved in this whole issue that the former planning director in 2006 went and met with my client's lender and assured the lender that what was going on in the property was lawful, that going forward, staff had every intention of supporting the project, that they saw no reason why the county wouldn't approve the project, and in fact gave the bank a timeline for when this would happen. So the idea that perhaps staff was not involved in that determination, or staff was not fully aware of it, and that again is not supported by the record. There's two things that were clear. One is that the Nevies were told at the time that it was okay. And
what was okay?
That the actual physical earthwork on the property did not require a permit from the county. And in reliance on that determination, the Nevies went forward, and the county cannot simply now step away from that determination, even if it now sort of says, gee, I wish we hadn't done that. The person that made the determination had the authority to do so at the time, had the support from the regulations at the time, and if the county now feels like, gee, I wish we hadn't done that and we shouldn't do that again, then the county's recourse is to change its regulations going forward, which I believe it already has, in fact, to address this issue. But not to go back where somebody has already relied on and spent money in reliance on the county's determination.
How much additional time?
I just need a couple more minutes to wrap up. So the letter of determination, which we're appealing today, says the denial of the previous project by the Board of Supervisors is tantamount to saying, well, you can't have any golf activities on the site. And that's simply not true. The project that came before all of you and before the Board of Supervisors, as you well know, was a much more extensive project. It included a subdivision, a lodge, residential development, and it was far more extensive than the relatively limited issue that we're discussing today. And none of those additional uses are on the table right now. The question, I think, for you all here today is whether an existing golf course with on an existing and active olive orchard that this supports the financial viability of that orchard, in fact, is permissible under the definition of agritourism that's in your code today. A property owner's right and freedom to sort of put their land to the highest and best use is one of the key and sort of founding principles of this country. And restrictions on that right are certainly allowable, they're certainly permissible, you all know that, but the rules have to be clear. And they have to be clear up front, not after people take an action, but they have to be clear up front, and they have to be applied even-handedly. And I think that in this case, you have to look at the definition that you have, apply it to the situation that you have, and if you're unhappy with the result that it yields, your recourse is to change your definition, not to sort of change the rules retroactively as they apply to my client.
Thank you.
Thanks.
Can you stay in front?
Sure.
I gotta ask you a question.
And that's the request to supervise. All right, thank you. Commissioners, any questions? All right.
Thanks for your time, appreciate it.
We may have to come back up.
Yeah, I've read sort of the procedures, and I know with you know, the procedures in the code, I think that were put up by the planning department, saying there's an opening by the appellant, and then the opponents, and then the appellant, and then the opponents again. We have a lot of appellants and opponents, I guess, here, so I would request that we get an opportunity to sort of come up and give a rebuttal after other people have given their side, if that's
The
okay.
public has the last day.
Thank you.
Good morning.
Good morning. I have some handouts here. I'm a Recreation Commissioner.
Ray, would you please state your name for the record?
Yes. My name is Ray Waller. And I have a couple extra copies of these exhibits for the person.
For those of you who may not know, Mr. Waller was the chief building official, I believe at the time that the application began.
That's what I'm going to say. This is
Oh, sorry.
At the time of the Trinitas Golf Course began construction, I was working at the county as the head of the building department, and I am familiar with what transpired and who was involved. After reviewing the Brent Harrington letter dated May 15, 2009, I found a couple of items that were either incorrect and needed clarification. First, Harrington's letter says, quote, "There's still disagreement about what you were told by county staff in the past regarding grading for a golf course, and whether your actions comply with what you were told." End quote. In late 2003, my department received complaints about grading for a golf course on the property. After investigating the complaint about no prevention of the work being done, I determined that the grading did exceed that allowed by the grading code. A citation was issued for the work to stop, and he was ordered to come into compliance. Prior to the citation process proceeding to the administrative hearing board, then Supervisor Erickson came to staff and requested that the item be pulled from the hearing board agenda and directed staff to meet with Neely and his engineer to find a resolution to the grading issue. Jeffrey's engineering then made an argument that the grading did not require a permit because an exemption in the code allowed the work if it was in a self-contained and isolated area and posed no threat or danger to adjoining public or private properties. Jeffrey supported the position by providing maps and data that showed the nature of the work going to the exemption requirements. After reviewing the documentation, I concurred and decided that the work could continue with the provision that Jeffries supervised the work to ensure that it continued to fall under the exemption, including erosion control, etc. Since code complaints had been involved, there was the concern that perhaps Fish and Game might have issues, and they were contacted with a request to visit the site and to forward any concerns they may have had to the county and Jeffries engineering. Proof of this action is contained in Exhibit 1. The county heard nothing from the state that there were any issues. In January 2004, the matter was considered closed and no violations existed. It should be noted that to date, no proof has been submitted that any of the grading work has done any damage to any adjoining properties. Harrington makes the same determination in his letter. It also should be noted that the building or grading code sections do not require a permit for a golf course. Second, Harrington's letter states, quote, "The board's denial of your project on May 12, 2009 effectively denies the use of your property for any form of golf, public, private, non-profit, or otherwise," end quote. During the situation regarding the grading issue, the county was looking into the matter whether Meany could have a golf course. This was an issue that fell under the jurisdiction of the planning department. Even though one of the planners decided that it was not allowed, planning director Bob Selman determined that the zoning code did not specifically prohibit it. matter was sent to County Council for an opinion. Council's determination was that a golf course for private use was allowed, and county staff informed Mr. Newman. Additionally, Ag Commissioner Jerry Howard, who oversaw activities on land under the Williamson Act and knew about the golf course, voiced no objections. As you can see from Exhibits 2 and 3, I emailed a complainant and county staff, including Supervisors Erickson and Fine, CAO, Tom Mitchell, Planning Director Bob Selman, County Council James Jones, and Todd Barr of Code Compliance, that the county had closed the citation regarding the grading issue, in addition to the fact that a private golf course was allowed. No one from the county on those emails responded to the contrary, nor directed Mr. Needy to stop any activities. In January 2005, I was asked to attend a meeting by Supervisors Walensky and Claudino. In attendance, along with Walensky and Claudino, were Mr. Needy and his representatives, Ag Commissioner Jerry Howard, Tim McSorley from Public Works, and Planning Director Bob Selman. Apparently, Mr. Needy had approached the county about making the golf course public, along with a clubhouse, restaurant, hotel, and other amenities. Staff was directed by the two supervisors to assist and advise Mr. Needy in how to submit the application and what are the documents and work needed to be done in order to process the application. Staff was asked if there were any obvious areas that needed to be addressed and if there were any issues that would prevent the project from proceeding. No one voiced any objections, and it was obvious that Walensky and Claudino supported the project with the direction they gave to staff. Subsequently, Mr. Needy and his agents submitted the application, and now appear arguing. I find it ironic that some people now say the golf course was built without county knowledge or approval. Obviously, that was not the case. In closing, I hope to set the record straight on two key issues regarding this project. Any questions?
Mr. Waller, what is your exact title?
Building official.
Did Fish and Game actually contact you after they visited? Initially, I'm looking at this exhibit, and I'm not exactly sure what you're referring to right now.
They did not contact me personally. They were contacted by one of my code compliance officers, and he was the contact person for that. He reported back that they said no. And I'm not sure if there was some other documentation in regards to that. I don't have access to that.
Okay, thank you.
Ray, when you were advised that there may be some illegal grading occurring on the property, what were you told was the purpose of the grading, or what type of project were they doing the grading?
Initially, we didn't know. We just heard that there might be grading. A subsequent complaint from the same person said that they heard helicopters out there, men with suits were running around, and it was popular on a golf course.
Did Mr. Jeffries represent to you what was going on as?
At that time, Mr. Jeffries had not, we were not aware of Mr. Jeffries being involved in that project. It wasn't until later on where we issued a letter to Mr. Needy, and then we issued a citation to stop the work. So, but there was no denial of anybody's part of it was going to be an intent of having a golf course.
At what point were you aware that a golf course was planned?
It was sometime after the complaint and the complaint process started. By the time we issued the citation, we knew that there was a golf course. That initiated the discussion with the planning department.
In your position as a building official, when you would forward a memo like Exhibit 2 here, and it's pretty much sent to some, pretty much the movers and shakers at phone displays, and they didn't respond, was that common for them not to respond to something that's fairly critical? I guess what I'm saying, would you regard that as you're not doing anything wrong, go ahead and proceed?
Yes. At that point, I was the lead contact from the county with that complaint, and that's what responded to everybody else to CC. Because they've had conversations with numerous county staff about this issue, and that's why I responded with the CC.
So you send them a fairly technical, full of information memo, and you don't get a response from any of them, so you just feel like, okay, I'm doing the right thing, so I continue to do it, correct?
Yes. And as was stated before, in regard to the grading, I certainly have that authority to allow the grading, so you need to separate that issue of what the building code says versus what the zoning code says.
Okay, thank you.
Anything else?
Thank you. All right, who would like to be next?
My name is Victoria Erickson. Opportunity to comment on a letter from Judge Harrington on the meetings, which makes the following statements. The board's denial of your project on May 12, 2009 effectively denies the use of your property for any form of golf, public, private, nonprofit, or otherwise. As a county supervisor from 2002 to 2005, I was involved in the county's investigation of the construction of the golf course on the Meade property. The county staff, in conjunction with council, had made the determination that the golf course was legal and that the Meades had the right to use it under county code and in its current agricultural zoning. I was included in the decision, and the emails denote that determination in Exhibit 1 and 2. There were several meetings with the building department and the planning department at that time. The second point I would like to make is that as chair of the Board of Supervisors, I signed a resolution amending the agricultural zoning codes that included the addition of agritourism. While being involved in hearings and discussions prior to the approval of the resolution, the agricultural community never discussed nor directed the Board of Supervisors to exclude golf or any other outdoor recreational activity from that part of the agritourism zoning code. As a matter of fact, at that time, at least 3 of the supervisors, myself, Supervisor Walensky, and Supervisor Claudino, had known that the golf course was in the agricultural zoning and that the Meades had the right to use it. In closing, I would like to say that it is unthinkable that now, after so much of the county's involvement in this matter, that Mr. Harrington's letter would even mention the removal of this golf course, and it is my sincere hope that this commission can lead the county in a direction to find some common ground in this dispute. Thank you for the opportunity to comment.
Thank you. Next.
Good morning. My name is Robert Cucinelli, and I was the business banking officer at the bank representing the Meades when they went through the process in 2006 to get the loan that they used to do a lot of the improvements on the property. I no longer work for the bank, so I had no access to bank files. That's what. Just wanted to make a brief statement on what I remember from the process. This was back in 2006. I had numerous meetings with the deans, and if you can imagine getting a loan approved like this, a lot of questions. And I also did have a meeting with a county planning individual who came to the bank and met with us. So I did all asked all the questions, this sort of thing. I can say in all fairness that nothing ever came up during this process of anything being illegal on the project, that the use of golf could not be used on the project, and I was able to get the project approved. So I think, a red flag like that had come up, I would have to say that something different would have happened in that loan approval process. So that's really the brief statement. I just wanted to understand that.
Did you know that it was subject subject to approval by the plant commission and board of supervisors?
Yeah, we did.
So you went ahead and approved the loan prior to those actions?
Who were the county officials you spoke with?
There was one lady, I don't have the file in front of me, but I know her name is Stephanie, Morita.
Thank you.
Thank you.
Who would like to be next?
Mark County, 121 East 11th Street, Tracy. I'm here on behalf of the Central Sierra Environmental Resource Center.
Hold a minute. Can you repeat your name again?
Mark Connolly, Connolly. I'm appearing on behalf of the Central Sierra Environmental Resource Center and KIRC.
What your comments are on this appeal?
Yes, we're opposing this appeal, asking that you deny the appeal. We're addressing specifically the issues that have been raised by the appellant. First of all, this is not a hearing to reconsider, re-adopt any portion of the Calaveras County ordinances on what agritourism allows or does not allow, which seems to be what the applicant is requesting. To the extent that the applicant raises the issue about what the council called legislative history, legislative history in reviewing ambiguous legislation does not involve the testimony of individual people involved in the process whose opinions may not have been adopted by the county or the legislative agency. It involves the review of the history of the adoption of the legislation, and your staff has made clear that law was considered in the discussion of agritourism and was not considered an approved use. It does not have to be excluded, specifically named as excluded, not to be allowed in the agricultural zone. So to the extent you have supervisors, ex-supervisors coming up, ex-planning people coming up saying, I believe this is what the intent was, that is not relevant, it is not considered in legislative history. What is important is that the test everywhere is that there has to be a nexus between the activity and agriculture. And that does not exist in this case. Now, I'm sure you can go on the internet and you can find anything allowed somewhere with somebody arguing that it's agritourism. That is, again, irrelevant to what is happening here in Calaveras County. And if you go to any reputable, and we've included seminars at the University of California, Davis, and other people to discuss agritourism, the nexus is a critical element. So what we are saying is, in reviewing the legislative history, your county decided that golf was not a use that is allowed in agriculturally designated property for very good reasons that we're all familiar with when we reviewed the environmental impact report and the impacts that golf is having now in this agricultural area, exactly as was predicted in the environmental impact report that was presented to you. So I want to also observe that we tend to go into some what I would call legally ridiculous arguments concerning the approval of the golf course and what has happened in this particular case. For example, the most ridiculous argument, I think, is that because, from a legal point of view, is because the tax assessor somehow is taxing the golf course as a golf course, that this somehow means that you, as the planning staff, or the planning commission and the planning staff, have to allow golf to exist on that property. We're paying money for it. It's a ridiculous argument. There's no link between the two. The tax assessor is required by law to tax property and tax personal property even based on the value of that property, whether it's legal or illegal. If there was a house of ill repute on that property, okay, they would have to tax that house of ill repute at its value, real property value, and they're not implying that you approved it. Okay? So the tax assessor has to do his job, collecting taxes and assessing property, and you have to do your job, regulating land use. Another ridiculous argument is that a golf course, and this gets known as our appeal, a golf course can be allowed to exist on the property simply because it is landscaping. Well, this building is a pile of lumber. Okay? It is nothing more than an accumulation of paneling and tables and other material, but it is a building. To argue that a golf course is just landscaping is the equivalent of arguing that this is just a pile of lumber that we should be allowed to keep on the property. Another argument, and this gets into some of the individual comments that were made by some of the people who just appeared in supporting the project, was that somehow this golf course needs to be grandfathered in because the county knew about it. Well, first of all, the Jeffries letters and all the other correspondence made it crystal clear that the real intent of building a golf course was concealed. It represented that the grading was occurring for pasture. It represented that the grading was occurring for vineyards. And then it represented that the grading was occurring for a few holes of private golf. The representations that have been made to you by Mr. Waller are not consistent in any way with the documents that are presented in the record, and although I don't know exactly what you have in front of you today, they cannot be consistent with any representations that you have today. Quite frankly, in reviewing the records, I was shocked when I saw Mr. Waller's notation that investigation over. And quite frankly, I have never seen anything like it and never have, whether it was an instance of just gross negligence on behalf of a public official, or whether it was for some undue influence. I never have been able to understand that. But prior to that point, the record before you makes an absolute clear written documentation that the purpose of this process was this construction on this property was misrepresented from day one. Another legally ridiculous argument, for example, is to have a banker come up here and say, "You lent money on this project, and we were told by planning staff that it was okay." The law is crystal clear. It is not only crystal clear in the law, it's totally unreasonable. And no lawyer, no banker would allow funding or financing of a golf course on Williamson Act property. When this project began, this construction and grading was occurring, this was Williamson Act property. Under state law, golf courses are not allowed on Williamson Act property. So there can be no argument that any reasonable person should allow, that you should be allowing today this golf course to continue on this property because there were gross mistakes made in the past by some planning, some county enforcement official who was derelict in his performance of his duties, by a banker who loaned on real estate property, by a developer who misrepresented the purposes of what he was doing to get those approvals. Don't compound that problem today. Those things and those legal misrepresentations and those legal errors do not justify further legal errors today. And misrepresentation of the history of this project and the legislative history do not justify allowing what would be an opening of the door of any type of use of agricultural land. And I heard one of them argue that it should be allowed because it helps finance the agricultural activity. Well, let me go back to my good example of House of Ill Repute on the property, what helps support the agricultural activity. It has no nexus to the agricultural activity. That doesn't make it agritourism. It may be fun for some people, but it doesn't make it agritourism. Another legally ridiculous argument was that we went to Fish and Game and we asked them, we sent them a memo, we wrote them a letter, I had a planning person contact them, and they didn't say anything in response. We know what the process is because we went through the environmental impact report process. Fish and Game, U.S. Fish and Wildlife Service, EPA, those agencies do not give advisory opinions when somebody calls them up and says, this is what I'm doing, is it okay? The process is that they come to you with a project, there is a notice of preparation of an environmental impact report, they are obligated legally to respond at that point, and EIR is circulated, they respond at that point. They do not give advisory opinions because somebody from county planning staff calls them on the phone and says, do you think this grading is going to environmentally violate the Endangered Species Act? And that's what happened here. Mr. Neely went out, the Neelys went out, they broke the law, they violated the Endangered Species Act, they violated CEQA, they violated the process by which Fish and Game would have given the official notice to which they would have to respond, to which they eventually did when they were forced to do an EIR. They took endangered species with that grading. And U.S. Fish and Wildlife Service is not advised or required, neither is the Corps of Engineers, to come back and say, stop the grading that you're doing without a permit because you're violating the Endangered Species Act. And we think if you continue doing it, you won't violate the Endangered Species Act. The process was bypassed by the applicant, resulting in the very things that they are complaining about now or using as justification for their project. So to get back to the basic issues that's before you today, it's a very simple one. Is a golf course, and the applicant has made it clear by his behavior since the denial of this project, advertising a fully run operational golf course, the gates are open, people are lined up, from radio stations to television stations to the internet, that he is going to operate a full-scale golf course in agricultural land. That is not an agritourism use. It is not consistent with your zoning for this property. It was denied, and the question I would ask you, if it was consistent, why did we go through that entire hearing process with an EIR where there was a zoning change application for this project? He didn't need to do that. We're only coming back to you now because that project was denied. We knew it was inconsistent with the zoning. It's not agritourism. He's gotten a letter which tells him to stop it, and he's going back to an argument that was rejected long before we began that process, and because he began that process, he knew it was rejected as well. So the request on behalf of both the Central Sierra Environmental Resource Center and KIRC is that you reject this revisionist history of what happened with this project, that you reject the ridiculous legal arguments that are being made, that you consider both of our letters and our reasons for objecting to it, and you deny this appeal.
I've got a question, Mr. Conlon. You stated that in state law, in the Williams Act contract, golf is illegal, and I was wondering if you could tell where you found that out, because I've been looking for it and I can't find it.
I litigated a case probably 15 years ago, I believe, where we were, it was actually a golf course case out of Stockton, I believe. But I can get you the citations on it. It's just, it's
but
not.
There's nothing in the state code that says, because that's kind of what you're referring to, and I've been looking for it, and I can't find it.
Well, that is the law, and I'll get you the citations for that if I need to. I litigated the case, like I said, where there was a golf course issue. We were, in fact, if I remember, it was a equestrian center golf course out of Stockton. It was on Williamson Act property. The issue was cancellation of the Williamson Act because the Williamson Act had to be canceled in order to allow for this golf course to be constructed. And the law hasn't changed since that time, so we briefed it real extensively. In other words, golf courses haven't been added as allowed.
I'd appreciate knowing the code of that.
I'm sure
Okay.
council can provide that.
Right. I don't really think there's any dispute about that legal issue. They're not arguing that.
Right. Thank you. It's not the intention of the Planning Commission to rehear the Trinitas project. We're here to deal with the 3 appeals, and I know it's tempting to get off and rehash that whole thing, but I would ask that everybody please limit your comments to the appeals with the recognition that the Board of Supervisors has taken action on this project. All right, who would like to be next? And please keep in mind we ask that you keep your comments as brief as possible. Good morning.
Good morning. My name is Al Segal with the Colorado County Taxpayer Association. We've spoken before you before, and also to the Board of Supervisors in support of the project. My remarks will be very brief. The main concern we have is with the property rights of the applicant. We feel that a catastrophe is happening here in justice. The government should be there to protect our rights, including property rights. We see it as We see the planning commission as the front line for that protection. We can't necessarily look to the legislature for protection, because quite often the legislature makes mistakes, but the mistakes need to be corrected at the front line. There will always be human beings that want to control their neighbor's property. There will be human beings with malice that would want to harm their neighbors. But in our system of American justice, these people cannot do this, or ought not to be able to do this using the law. If a group of people who, out of malice, want to destroy their neighbors' rights to do with their property as they wish, and are not stopped, the result will be an economic catastrophe. People will not invest in property in which it's doubtful that they'll be able to build anything, even a home. So, above all else, I think in terms of law is our U.S. Constitution, which is there to restrain government and to protect those individual rights. And so what I'm asking you to do is to consider that Constitution and ask the question, did the applicant do anything to harm his neighbors? That's a good justification for government suppression of his activities, or even to ban him from using his property. And if the answer to that question is no, then it follows that he should be allowed to use his property as he sees fit. Thank you.
Nowhere in the record can I find any evidence that the agricultural community ever instructed the Board of Supervisors to exclude any form of outdoor recreation from the agritourism zoning code. The ag community has always favored a broad interpretation of the code to allow as many uses as possible. Hence, the code states, examples of agritourism enterprises include, but are not limited to. This is contrary to the staff report's statement that if the code is silent, then the use is not allowed. That's baloney. Just the opposite. The code actually says that if it isn't listed, then it can be done. The County Code Section 17.16.020 permitted uses. 21, recreational and educational. Item A, agritourism activity not otherwise specified, less than 75 persons on site at one time. This part clearly spells out that recreational uses are encouraged under agritourism zoning. Golf is clearly recreational. By definition, the Mimi family's golf course and farming operation meet the criteria for being defined as agritourism. They have a working olive ranch and farm, and the family produces and sells a number of their products both on site and in various markets. I've also read letters from Ken Churches, our local expert farm advisor, who characterizes Mimi's golfing activities on their working farm as an excellent example of an innovative agritourism operation, much like the type of activities that occur at Ironstone Vineyards in Murphy's. I urge the Planning Commission to rescind Mr. Hampton's letter and issue the interpretation that golfing on a working farm is consistent with agritourism zoning code. Thank you. I have copies of this if you would like.
And please give them to staff.
I'll hand it to you if you just want.
My name is Kathy Mayhew, and I'd like to address Mr. Mason's question about the, I think it was Mr. Mason, I'm sorry, start over again. The whole issue of when the golf course was built, whether it was under Williamson Act, and the issue of whether golf courses were allowed under the Williamson Act. One of the items that's in the public record in a number of occasions is a letter written in June of 2008 by a county planning staff member telling the Mimis on a hearing that the surveyor told neighbors that a golf course was being surveyed for. The planning director wrote a letter, and I believe it was at Mr. Waller's suggestion at that time. It was it was actually, I believe, August 9, 2001, sent to the Mimis that said that under our county ordinances, a golf course is not allowed under Agriculture A1 or AP, nor is it allowed under the Williamson Act contracts. They had 2 Williamson Act contracts at the time. We thought there was only one, but one did not expire until 2006. By that time, the notice of preparation was out for the EIR. The application was submitted asking for a zoning change to recreation in order to allow the golf course to be opened as a public facility, and that by 2006, after the first scoping session, Bob Selman, who was interim planning director at the time, wrote the Mimis another letter saying, at this time, a golf course is not allowed on your property under its current zoning. A1 or AP, a golf course is not allowed, and told him to stop both the any use expansion or modification, some other words to that effect, of the golf course at that time, and to wait until the project application, the EIR was complete, and the Planning Commission or the Board of Supervisors made a decision about the project that no other use or expansion, alteration of the golf course was to occur. In February, I believe, of 2008, the State Department of Conservation did an audit on the Williams Neck contracts in this county. What mostly hit the newspapers at that time was questions about prime land versus non-prime ag land, and the county was required to begin giving back some money to the state because of that. But I believe it was on page 17 and 18 of that audit document. There was a Situation 7 specifically called out, and while it did not mention Nimi's by name, it mentioned the parcel number of the parcel that was 120 acres at the top of the 280 acres, and it said that if a golf course was built while this property was still under the Williamson Act, which it had been, that it was a breach of contract. Now, there was no follow-through on that, to my knowledge, but the State Department of Conservation said in that in their description of Situation 7, this was in early 2008, it said in approximately 8 years ago, the legislature determined that golf courses were not allowed under Williamson Act contract. So those are a few of the specific times that the applicants were told that a golf course was not permitted under Calaveras County Code for ag preserve or A1 property. I'd also like to say in terms of agritourism that Mr. Churches in his letter referred to this document, Agritourism and Nature Tourism in California. This book has an entire chapter on navigating legal constraints. And one of the first things it said, it says looking at basic categories. To start an agritourism or nature tourism enterprise, you must comply with local requirements or obtain county zoning approval. That's right here. You must adhere to regulations that protect the environment, your neighbors, and your visitors. The following list describes broad categories relative to agritourism and nature tourism: land use and development, environmental health, public safety, licenses, taxes, and other things. But they go into great detail in trying to explain to someone that before you build your agritourism activity or project on site, that there are a lot of regulations, county, state, and federal, that must be looked into and carefully worked into the plan of developing your agritourism project. So that's before you build it, not after the fact. Thank you.
Thank you. Who would like to be next? I think this woman was coming up first. Go ahead.
Good morning, how are you? Thank you very much for this opportunity to speak about this project.
Please state your name.
Jean Young, and I do want to tell you I live in that neighborhood where the project is. It only benefits everybody in West County to have this project, but there's a lot of things that have been talked about, but none of it really affects what the county has done about this project. You can't go backwards for what the old county leaders have let pass and what the new county leaders are listening to now. This project has been passed through everything, but yet then now it's being complained about. So that's one part. Common sense is sort of falling through the cracks here, where our county's economical basis is just downtrodden right now. We need every bit of tax revenue we can get, but yet then this project was turned down. So that kills a lot of property tax values throughout the whole area. The environmental impact study and what they're talking about the land being graded, all of that stuff. Where we live, If anybody drives out there, can see that every piece of property, 5-acre property, has been requested by the county to dig a big hole in it for a pond. But yet then you're complaining that he did it right. We just dug a hole, and it's filled in the wintertime by runoff and dries up in the summer. But yet then ours is okay, and what he did is wrong. Now, I think we need to fact study what is going on here. It's about a few people complaining, a few neighbors. But every neighbor I have talked to agrees with this project. We want the empty houses to be sold in that area. We want the 5-acre lots to be sold. This is the only golf course in the world that I've studied that has 5-acre parcels around it. Most of them have a congestion of houses that eat up our infrastructure. This is bringing something in and not eating up our infrastructure. So that's one thing. Something else is that I'm really confused on the people that are opposing this project. They think it's the right to stand up here and oppose what Mr. Needy is doing. But yet then, they think it's perfectly right to stand in their backyards and take pictures of their neighbors. Totally invasion of privacy in that area. One person climbs a ladder to take pictures of their neighbors. This person thinks it's right to stop in the middle of Hospital. If you know the road, this here goes up and down and up and down. Many times I have come over that hill with that person sitting there spying on her neighbor. Now, you have to think of the mindset of somebody opposing the project that doesn't mind getting in other people's faces with what they're doing and taking photos.
Mrs. Down, I don't think that's really pertinent to the appeal. Why don't you conclude with anything?
It is pertinent to the fact that
we have no control over people stopping on the road and taking pictures, is what I'm trying to say.
yeah, I mean, I know you don't, but the fact is that the mindset is there, that it's their business, what everybody else does. But it's just they don't agree with what Mr. Needy is doing, so they're opposing the whole project. And I thank you very much.
I'm Kathleen Jackson, and I'm in opposition to the appeal today. My background and interest has always been the protection of the watershed, ag land, our breadbasket, and so forth. I want to go back just to the simple logic of personal property rights. When the applicant purchased 2 very large, over 280 acres of ag preserve land, he knew full well what his rights were. Those rights are limited to the zoning and land use designation that existed at that time. This applicant also had built golf courses before. He was well aware that there must be some process. The only reason you have authority today to sit on land use and zoning code situations is because you represent the code, the law, the authority of the police, if you will, to protect any negative impacts against our citizens, our community and neighborhood, and so on. To say that I, who purchased a certain type of land, have a right to metamorphose it into any other type of land just doesn't hold water with me. I'm well aware that the golf course is beautiful, that it may have tax and sale revenue benefits, but what is it taking away? I also sit on the Water and Wastewater Forum, very interested in community design, and it doesn't take much imagination to know that subdivision projects will come before you associated with this western end of the county. I happen to know that CCWD holds a list of irrigators, farmers, and cattlemen still looking for additional irrigation water right in the western end of that county. So what you're choosing between is what was the land supposed to be, what does the code and law say it should be, and you uphold the law, because I don't believe any man or applicant stands higher than the law. This applicant was offered a general plan amendment by the planning department in the administrative hearing when they understood what he was really up to. He denied that. He wanted to go with the recreational tours, the agro-tourism definition, and so your decision today is looking at one little microscopic piece of it. That's about all I have to say, and I didn't hear a speech. I'm just here saying he's using water that is not on public and is draining an aquifer that is already depleted, and that's been the whole fight from the beginning. Thank you.
Good morning. My name is Lynette Hospital. I reside on 9664 Hospital Road, right across from Trinidad. I oppose this project, or I want the denial of this project for several reasons. This is AP zone, agricultural zone that is under the Williamson Act. The Williamson Act protects agriculture. We don't protect agriculture now. There's not going to be any agriculture for the future. Also, water. I brought my filter. I changed. We had to go deeper in 2007 and on well. In April, before the meeting, I had to have our drill people come out because I couldn't get my filter off. That we had to drain our tank, all full of sand, and the filter was all full of sand. Okay? Just in August, that's 3 months later, I had to call him out again. This is the filter. And with the normal filter, you're able to go 6 months. He's suggesting I change it every month. It costs me $133 each time he comes out. And then my animals have to have sandy water all the time, just about. So water is a big issue for me and the road. It's not designed to have all those people come to go golfing. And you like all those neighbors telling us it was just going to be a private golf course. Then it ends up being an empty hole golf course. I'm just saying this, I have sheep, we have sheep, cattle, livestock. They have to have water. When my pump goes down, I have to call the pump man, and it costs me money every time. So, like she said, the water is a big issue. And agriculture. We have to preserve the land for future agricultural use. So I suggest that you adjourn this project. That's all I'm going to say.
Thank you.
My name is Frances Miller Sands, and I live in Dallas. And if my comments are out of context with what you know about this town, I'm more than glad to just go and sit down again. But it was mentioned the older, not laws, but permits, county permits. In 1990, we put a modular home on our property. And the building inspectors were wonderful, easy to get along with, not a problem. But what happened was we had taken our furniture and put in our home because we had a final inspection lined up. So the inspector came, and it's sort of funny now when you think about it. It was a real problem at the time. We had steps going up to the front porch, and there was a rail, and there were pickets that had to line up on the rail. And the pickets were sitting there. They were going to go in later that day. Our son-in-law was going to put them in. the inspector came out and he said, no, he said, those are not on there. I will not pass this until this is done. We could not live in our home. I don't remember if the inspector, he was a good person. I'm not complaining about him, he was a good person. I don't remember if it was the following day or if it was several days. But he would not pass inspection until those pickets were on that rail. I mean, there were 4 or 5 pickets. But there's a name for what we were. It is called law abiding. And it is true that people have the right to use their land the way that they want to use it. But when you buy land, you know with the zoning, with the codes permit, and if you go in there and determine that you are going to turn this all around and disobey it, that's your problem. That is your problem. But we did what was right. We were not allowed to stay on time. But we put pickets on there, the inspector came out, we passed. We have a wonderful, wonderful home. And this does go back a ways. But what we had to do, I think everybody else would have to do it. It is called abide by the law. It's that simple. I forgot to sign in, I'm sorry.
Thank you. It would be good if it was simple.
Hello, we are Sharon and Eagle Scotto. We live in Valley Springs, and we want to comment on the staff report and Mr. Harrington's letter, stating that the communities are allowed to have a golf course, but they can't use it, or the county will take action to remove it. This is so absurd. It sounds like something for the Guinness Book of Records on cruelty on behalf of the county towards its residents. The county let them build the golf course, and now they are telling them they can't use it. Some of these things have already been said, so I won't repeat everything. I'm wondering, have they moved Calaveras County and we now live in a communist country where the officials change their minds whenever they please? This is America. This county has led this family up and down the ladder in this process for the last 5 years. Mr. Harrington's letter is contrary to the actions of the county dating back to 2003. We should be able to rely on what our county officials tell us. The county is laying off people and cutting services because of the recession we are in. Isn't it time for our county to welcome Trinitas County and the revenue the tourists and the golfers will bring in? Keep it rural group should be happy to have a beautiful, prosperous golf course in West Calaveras, because it means some people with money will be spending it here and then going home. The only tourists we have now are the people who come to camp at the lakes. They buy a few beers and they go home. Our county is not going to make anything off of them. And the environmentalists, if they ever get out there to see it, would positively love Trinitas. We urge you to rescind Mr. Harrington's letter and give back this family's property rights and dignity. Let us again believe in America, the land of the free. Thank you.
We're going to take a break at 10:30 for about 5 minutes or so.
I can get in before you're 10:30. My name is Jeff Neal, and I'd just like to point out that the appeal process should be that you obey the law. If you don't like the law, you appeal it. I've been in this room several times when they've been told not to golf, and they're still golfing, and they're advertising on the front page of the Stockton Record to kind of sign up for your tee times. And I think that's a crucial issue in this whole thing. They've been told for at least 2 years ago not to go, and they're still golfing, and they're still advertising golfing, and I don't believe that in the nation of laws, that's how things are handled. Thank you.
You're welcome. Anybody want to get in before 10:30 as a brief comment? All right, then we'll go ahead and break now and resume hopefully right around 3 appeals a year, and the appeals center on the issue of golf. And so we have heard many of the comments having to do with water and property rights, etc. But what I'd like to suggest is that we take a look at the appeals, have the comments refer to the appeals themselves. I'd like to wrap up testimony on this first appeal within the next 10 or 15 minutes. So that would be testimony from the public and any response from the applicant, so that we can move on to the other appeals. So, who would like to begin?
is Joseph Pacelli. I live in Valley Springs and work in Valley Springs. I have an office at 15 St. Andrews, which is right next to the Rocky Temple golf course. I've been listening to the various arguments, and as he stated, you really hear about the letter of May 15th, 2009, which seems to suggest that the county can tear out a golf course that has cost the Nemes a tremendous amount of money, and to their mind was approved all the way. I don't know that there's any moral or legal reason to justify that sort of action. I have personally been on the course recently, and I had actually been to it a couple of times for some charity events. I recently walked the course. I was amazed at the incredible amount of, I suppose there was mitigation, habitat that the Nemes had installed to encourage wildlife, fish, everything. It's an absolutely stunning course, a stunning piece of land, the way they built it. And I hear one person here opposing it from the Environmental Resource Center. I don't know what they do, but if they're actually in favor of environmentally good projects, I don't know why. The claims that the Nemes somehow changed their mind or defrauded the county, is what I keep hearing people say, just seem to be false. I would ask that the commission grant the appeals. All I see is people up here, some people who seem to have a lot of jealousy or vindication in their motivation. I hear about the one lady with
Sir, if you'd like to focus your comments on the appeal, please, and not on personalities.
I've been talking about the letter of May 15th and the intention or the desire by the county to tear out the golf course. I don't think it makes any sense. As a businessman, I've seen the county do several things in the last few years that just totally discourage business, and to deny this golf course would do exactly that. I think we need to look at the big picture, and I have asked you to grant the Nemes the right to use this course as they thought they were originally allowed. Thank you.
You're welcome. Who would like to be next?
Good morning, my name is Bill Davies, I'm from Murphy's, and at the risk of being repetitive, we hear I talk a lot about what the appeal is for, what its the basis is, and so forth. And I think one of the things that being from Murphy's that we see out there is we have a perfect example of what can be done in the ag zone, and that's the Ironstone Vineyard project. And that, I'm sure, when it opened up 15, 20 years ago, was probably just as controversial as the Pentecost project is today. But the thing that's important to realize with that is it was a broad scope applied to that project, and it's the same broad scope you have the opportunity to apply to this project as well. And the fact is that one of the things the county code doesn't really specify is you have the use that's listed, but it's not limited to just that use. So you have the opportunity to be a little bit more open what you can consider to be a usable circumstance, like we have in the So if you look at the Ironstone, for example, it's an ag use with the vineyard and the winery, etc. But it also has concerts, car shows, it's got a jewelry shop there, a restaurant. But the only thing it doesn't have is a hotel. But it's turned out to be a very compatible use for that area. And people at Murphy's will say that's what brought Murphy's back to life 15, 20 years ago. And that's the perfect opportunity you have here with Trinitas. Trinitas, if you give it a broad interpretation and allow it to exist, because in the code you can allow for an outdoor activity, we already call it an outdoor activity, then certainly you can use that interpretive powers to this appeal to allow that to take place. And if you do that, I think the benefits you'll find that for that area have been or will be just about what they are and have been for Ironstone. And we're going to have an opportunity here to make the West County area come along. And I think that the people that are opposed to the project aren't willing to give that project a chance to see that it can be compatible and that it can be a benefit to everybody who lives in that area, from the property rights that they have, to the property values that will increase, to the businesses that will profit. Everything has a chance, if you can use your broad powers here, to let them take that first step, show you that the golfing is compatible, and then let them come back with the future steps that they prove to you that it is. I think it's something that folks have the power to grant. Thank you.
Thank you. Anyone else? All right, was the agents for the appellant like to take a brief comment?
Thank you, Christine Griffith again. I did just want to make a brief rebuttal to some of the points that were raised. I'll try to move through them quickly since it's dragging on. I appreciate your time. Mr. Connolly suggested that we were requesting a legislative revision. This is actually the total opposite of what we're asking. What we're asking for you to do is apply the code and the plain meaning of the words that are there on the page that say that it is a non-exclusive list, that it has the following examples, but it's not limited to those examples. There is no formal legislative history, as I pointed out, and Mr. Connolly, I think, criticized us for having referred to the recollections, the contemporaneous recollections of the people that were involved in drafting the language. Certainly it seems to me that that's more relevant than what the current staff's opinion is of the intent of the ordinance. In addition, the intent of the ordinance is right there in there, and it says that the intent is to enhance the commercial viability or the economic viability of agricultural land. He stated that the test everywhere is nexus, and that's true in some areas of the law, but not in this one. The test here is, what does the code allow or not allow? There is no requirement for there to be a connection between the agritourism activity in the way that Mr. Connolly is suggesting and the agricultural activity. All of the literature on agritourism makes it clear you can have stuff that has nothing to do with agriculture, like a car show at a vineyard. It has nothing, one has nothing to do with the other. He was critical of our point about the tax assessor, and I wanted to, as a result, clarify the point that I was making, which is just merely that the county needs to be consistent and on the same page. It doesn't mean that the tax assessor governs land use or vice versa. It's a piece of information that I think is useful to you in making your decision today. No, we've never asked to be grandfathered. I don't know where that argument came from. We're asking for the code to be applied the way that it's written. There was much discussion about the Williamson Act and its intents and purposes and applicability or no applicability. The reality is this property is not under a Williamson Act contract. That issue is irrelevant at this point. In addition, when the audit was done in the county on Williamson Act, no notice of violation or notice of breach of contract that was issued to the Nevies under the Williamson Act contract. There's just simply no evidence to support it. If the property were currently governed by a Williamson Act contract, I think that discussion would be relevant, but it's not, and so I think it's irrelevant. Someone stated that you would be opening the door to all kinds of uses, and I don't think that that's so. There is an agritourism ordinance that allows uses on agricultural land, and if the county is now unhappy with how broad that language is, the county may go back and revise that language and limit it if you're concerned about opening the door. In addition, there have been changes to the grading ordinance since this occurred that might indeed require a permit for the same activity that did not require a permit at the time. Financing agriculture is the purpose of the agritourism ordinance, and so sort of opening the door to all kinds of activities that could bring money into farms is kind of the purpose. So if that purpose is no longer desirable, then the remedy is to change the ordinance, not to penalize somebody who's currently complying with it. And in this regard, there were some references to a house of ill repute. I'm not exactly sure what the implication is supposed to be there. I don't think anybody is arguing that there's some connection between the golf course and the use that Mr. Conrad is suggesting. Perhaps be interesting to know that guest houses and lodging are in fact allowed, so I don't know, maybe that has something to do with it. There was mention of Endangered Species Act and state species violations, but there's never been any evidence presented to support those allegations. The Department of Fish and Game has visited the site more than once, has never issued a notice of violation. If alleged violations and takings of species were so clear, where are the resource agencies that are in charge of this? I mean, there has been no violation issued, and the mere allegation that there were violations doesn't support anything. And in fact, the DFG inspector that came out said it would do more harm to the environment to remove the golf course than it would to let it be. I said 3 more quick points. The previous proceeding, as I mentioned before, was for a far more extensive project, and I don't think you should let yourselves get sucked into that temptation of saying, oh, well, we're looking at the same thing again, because you're not. There was some discussion of water usage. I'll point out that if the entire property was planted in olive orchards, it would require a lot more water use than what is currently required to maintain the golf course. And there's been a lot of discussion about code compliance and people talking about their own experiences with code compliance, and I think that the lesson or the conclusion from most of those discussions is that everybody seems to think that, you know, you go to the county and you get a determination on code compliance that you should be able to rely on it, including the woman who had put the things on a railing relied on what the inspector told her. And, you know, that I think is a principle that can't be ignored. So the code here allows the use. The use is permitted. If people don't like the code, they can now change the code, but you can't retroactively change it and apply it differently to our client. Any questions?
Were the ag contracts relevant at the time that this project was beginning to be built? Were the ag contracts relevant then?
You know, the Williamson Act is, I mean, it's an interesting act the way that it works. And as Commissioner Curry pointed out, you can find anywhere where certain things were not allowed. What I will say is that there's nothing in the Williamson Act that would have prevented grading. One of the contracts was terminated, one of the contracts was on its way to termination, and that the Williamson Act is, to the extent that it limits things, it limits uses that are inconsistent with the agricultural use that is committed to under the contract. So grading is not a use that is necessarily inconsistent with an agricultural activity under the Williamson Act. If the property was currently under Williamson Act, would an active golf course be an incompatible use with agriculture? It's possible, although I have to say, again, I have a lot of experience with other properties under Williamson Act along the coast and some other areas of the state, and the rules on what you can and can't do or what you must and must not do under the Williamson Act are very much in flux. There is consideration in the state of just doing away with the whole thing altogether because maintaining an economically viable agricultural operation and not being able to do anything else with your property has not proven to be a very workable system in many parts of the state. So, I mean, that's sort of a longer answer than you asked for. I think the short answer is that the activities that took place at the time that there was a Williamson Act contract on this land were not in opposition to that contract.
The building of a golf course?
There was the activities. You have to look at the specific timing, and I can get the dates for you if you want. I don't actually have them right here in front of me.
I'm aware of the dates.
But the activities that took place while the contract was active were not in conflict with the Williamson Act, and like I said, during the county-wide audit, they were never found to have been in violation of the contract.
I got to carry that issue with the on the agenda here.
what we're all sitting around here spending our wonderful time doing, number one, it says here that the appeal to the 4 or 5 names of the lawyer office on behalf of Michael and Michelle Meany regarding the use of a golf course, golfing on the premises, as a legal permitted use on property with the zoning designation of agricultural reserve.
Correct.
Now, that's what we're, what it says here, we're looking at the fact that it is in the agricultural preserve.
Correct.
And that is, you're saying here, in other words, with all the work you're saying that it is not. You said it wasn't in ag preserve, so the appeal is saying that it is.
So I'm glad that you asked that question, because I think it's an important distinction.
Try not to be a lawyer and make it short, because I don't want to hear about lawyers.
I'll do my best. I promise that I will do my best. The zoning and the Williamson Act contract are two different things.
I know that.
And your zoning code, including the AP designation, allows agritourism activities as that's defined in the code.
That's the question, right?
No, it does allow agritourism. The question for you is whether golf is agritourism. So the Williamson Act contract is a completely separate thing. There is some overlap in the two, but not in this case.
We're going further with that. Ag is a production activity. Golfing is a consuming activity. And we are here to preserve the production activity of agriculture. That's why I say an ag preserve. And the problem is that if it wanted to be something else, which is a consuming part, it should get out of the ag preserve and not stay in that. So that trips the wire.
I can see where you're coming from on that. From a theoretical perspective, the problem with that is that your zoning designation for ag preserve specifically allows agritourism. And it specifically allows some of those, as you call it, consuming activities, because on the flip side is that you're providing some money to help people keep their agricultural activities. Now, if the Needies were to get rid of their agricultural activities completely, it would be a totally different situation.
That's not the point.
The idea is that one helps support the other.
This is an opportunity for rebuttal.
I'm sorry. Was there anything else?
No, I don't think so.
Okay.
Commissioners have some questions. All right, now, the public will have a brief opportunity to comment on what the applicant's agent has just commented on. That's it. We're not rehashing the previous testimony. You have an opportunity to comment on the rebuttal. Is that clear? So is there anyone who would like to comment at this time?
Mark Conley, 121 East 11th Street. The issue is, I agree, is a very narrow one. She talked about, I'm sorry we got off on the Williamson Act. The issue is whether the language of your code, whether this is allowed use in agritourism. There was a statement earlier that the language not limited to, therefore opens the door to all uses. And what I just heard in the rebuttal was the argument that, well, it doesn't open the door, but then again, it does open the door to every kind of use. And the consuming versus production analysis is a good analysis and one way of looking at it, because what you're basically saying is any kind of use that any product that can be consumed is allowed in agricultural land. I want to go back to the EIR in this case, which you're all familiar with, and maybe the new council isn't, but if the purpose of agritourism is to protect agricultural land, that EIR was excellent in identifying the fact that the most significant unavoidable impact was the impact of surrounding agricultural operations. So if the purpose of your agritourism ordinance is to promote and protect agriculture, the EIR is the strongest evidence, you're all familiar with it, that we saw demonstrating that this use, golf courses, and this particular project are in the wrong place, are incompatible with agriculture, and in fact damaging agriculture. Accept all of our arguments. You have to say, is this the kind of use we want in an agricultural area? And if we were going to consider legislation, we were starting from scratch, the answer is still happening. No. Thank you.
Thank you. All right, any questions, commissioners? Do you want to take action on this appeal now or postpone action until you put testimony on all three appeals? What do you recommend?
I think you could do it either way. The arguments are obviously different and on both sides of the issue, actually. So I think you probably could deal with this appeal and then maybe deal with the other two appeals at some time. Seems to make sense to me. But again, it's the desire of the board to do what they'd like to do in this case.
Any comments?
I guess I'd be tempted to take them individually. Since this is more expansive than the others.
Right?
Well, yeah, absolutely. I'd just like to do as we cover also because I'm going to refresh your mind on that usually.
And the action we take on number 1 may affect number 2.
Yeah, absolutely.
Then I will close the public hearing and ask staff to read the recommendation, please.
Based on the whole of the record, staff recommends the planning commission pass a resolution denying the appeal of Michael O. and showing in its entirety.
Is there a motion to that effect?
Are we going to discuss this?
We can discuss it in the motion.
I'll make the motion, but following discussion.
I'll say it.
Discussion?
Usually we have a comment from the commissioners, so kind of.
Oh, I'm sorry, I thought I asked if anybody had comments. Go ahead.
To me, this is a couple different questions. Number one is the activity permitted on the property. In a private sense, I don't see that it's not permitted any more than playing basketball or somebody setting up a volleyball net or archery. It might be shot on somebody's property at hay bales. I don't have a problem with that. I think the other question is, and I still have it as a business, and that is a decision that I think is being made. Is he allowed to do, or the meeting's allowed to do business as a golf course? And is it something that coalesces with farming activity? I think he is increasing the agriculture over there. He's actually, when we toured the property as site commissioners with the planning director, we saw him saving old trees that were basically going to be bulldozed at other properties and planting new, smaller trees, and his adjoining family on their adjoining properties is also planting trees, so they're actually increasing agricultural production. I don't think it's decreasing. And he's also promoting the products all by attending the local farmers markets, and I've seen him on cable TV pushing it. And I've even seen it for sale outside of the county. So I do think he's making an effort to increase the agriculture that's going on in the store, not decrease it. I think it's preposterous to think that it's landscaping, and I agree with that. It is a golf course, and I don't think you need to have good vision to see that. The agritourism, I do understand that cases have been litigated that actually create laws that state that it's not allowed on a JP zone, but we were also advised that the decision we make creates certain legislation that will go forward also. And I looked myself to see if we could find something that was comparable in a golf course that I've been on and adjoining to Bowling County's code. But they did allow the golf course, and frankly, when you're on it, you hardly know it's there until you're right there. The road is very small, that's just an word from what leads to the Trinitas property. And the attendance, even when the golf course is full, didn't appear to be a nuisance to me. I I realize that the road leading to Trinitas is not huge, but you're talking about an 18-hole golf course. We're not talking about the project in its entirety, a large hotel and a huge housing development. I was not in favor of that in the first place, and I know that that's not a discussion now. But even if you have every single solitary hole being played every minute of the light of day, that would only be 72 golfers on the entire place. It wouldn't be 72 cars. And we all know that that's not possible. I just rode by a very beautiful golf course on the way here, and there was one person playing that I could see at 8:30 in the morning. So it's not going to be constantly filled, but there is going to be increased traffic, and that is possibly something that they would have to address if they were to go forward. I do think that our vote does rely on code, and there is some interpretation of the code, but also our vote going forward does create new interpretation, and that's what I wanted to say. Thank you.
I have a comment, and that is, maybe I'm on the old school, but when you say agritourism, the thing that comes to my mind is an agricultural activity that has some related tourism aspect. Like if you have a vineyard, you can have tourists come in and learn how to prune, learn how to pick grapes, learn how to do the crush, as related to the vineyard. I don't really see much of a nexus between golfing and olive trees. And if you were to hold a poll, and I'm just supposing this, but if you were to have a poll down there as to why people are there, I have a hunch that very few of them would say we're here to pick olives or to look at the orchard, that they're here to play golf. So the golf course with a related agricultural thing, it seems a little bit backward to me.
Well, my comment is that it seems fairly clear looking at the code that, golf courses are permitted in the AP zone. I mean, that's like it's not permitted in the AP zone. It's, the Nene's have a golf course in the AP zone, so therefore I would think that the golf course is illegal. Also looking at the code, there are other sections in the code that address golf courses, so it's not like the county and its development of the code simply forgot golf courses. They were considered, and they are intentionally put in other parts of the code. So in the AP code section, there are uses that are permitted and ones that are conditional, and golf isn't in either one of those. Related to that is, if you consider that golf courses aren't allowed in the AP zone, I don't even know why we're talking about agritourism, because that's a benefit that goes with the AP code. So if they're not allowed in the AP code, then why are we even talking about a benefit such as agritourism that is associated with that code? It would be like if we were here talking about a grocery store that got built in a housing development in an R1 zone, and rather than talking about, geez, that grocery store is supposed to be there, we'd be talking about if the produce is okay in it. So I just, it seems like we've kind of gotten a little cart before the horse there. So it seems fairly, straightforward, to me that, golf courses aren't allowed here, and so, neither would the agritourism benefit go with that.
Bill?
Yeah, as most of you probably know, I wasn't here during the huge job that the planning commission did to hear this in its official probably most of it, I guess. And so, it's not that I'm catching up to it. I did read it all before I had to go do some personal things to keep me alive. But anyway, one of the things that is the problem I have is I didn't have a letter problem with the letter that Harrington wrote. Because to me, it told everybody what the basic floor was. And you needed to look at this, not muddy the water, not stir it up, but to do some things that would make everybody in the Wallace area maybe try to work things out and have a benefit down that area. But in my opinion, has not been the case. And I don't particularly want to be vindictive or nothing, but one of the things that it is what Fawn said was AP is there for a reason. And that is not what the golf course goes to, because the minute you start mixing rec with residential, or rec with agriculture, or rec with golf courses with manufacturing, so you may have a problem. And I think that's the reason why this was done. And I looked at this letter after all the decisions were made, and I assumed that the board supervisors looked at this and said, okay, this will put things in the direction we need to go. And if they have other decisions to make that can change things, that's their thing to do. And I just find it interesting, and I agree with the Fawn, in fact, that sometimes I'm curious why I hear this particular point. Thank you.
I would like to say that the Planning Commission, the Board of Supervisors, members of the public have spent hours and hours and hours commenting, researching this project. And the Board of Supervisors, after years of dealing with the many complicated issues of this project, denied Mr. and Mrs. Mimi's application. So in my opinion, there is no project. The golf course is not a project. The property is being used as a golf course. The property is being used illegally based on the decision of the Board of Supervisors. In terms of the appeal, well, first of all, it's our job to follow our county ordinances and our laws and to interpret them the best we can in every given situation and in every given project. That's our job, is to try and uphold the laws of the county. We can change the laws through a process. If the laws, the ordinances are no longer valid or appropriate, given the current situation, we can change those. But we don't have the opportunity to ignore them. And that's something that I'm not interested in doing. I'm looking at the big picture of the zoning ordinance in its entirety, how it's been developed and changed and modified over the years, and we have consistently placed in the zoning ordinance allowed uses that require conditional use permit. We've been very consistent in how we structure our ordinances. So I don't think that because there is some wording that this shall not be limited to, that means that everything else therefore is allowed. I disagree with that interpretation. Maybe we need to strengthen the language in our ordinances, but again, I'm looking at over many years and how we've interpreted and written the zoning codes. That has never been the intent, to just have things be brought up and, oh, well, it isn't specifically prevented, therefore it's allowed. That's not how we've done business. So I'm in support of the motion to deny the appeal. Any other discussion before we take the vote? All right, you have a motion on the floor. All in favor of the motion? Aye. Opposed?
Aye. No.
All right, the motion passes on a 4-1 vote. All right, we'll take up next item 2, appeal by Mark B. Connolly as legal counsel for and on behalf of Keepers Rural Calaveras regarding staff's interpretation that the use of the subject property is distinct from the physical aspects of the property. e.g. the golf course is landscaping, use of the land for golf course is allowed so long as development occurs.
Madam Chair, we have no objection to the appeal of the Central Sierra Environmental Resource Center being heard at the same time as once. The phase 2 issues are, if not identical, extremely similar.
The commission in agreement that
Well, no, both of those appeals address the issue of the physical golf course being allowed to remain on the property based on the action that you just took and various outcomes from that. So that's the core issue there with both of those appeals. So we don't have any problem with both of them heard at the same time. I think it is shortening the process.
go ahead.
Okay. So, Mark Conley, opinion on behalf of the Central Sierra Environmental Resource Center and KIRC. I'm going to make this short, famous last words for a lawyer. The issue here now is golf play is not allowed on the property. The issue remaining then is we have a physical golf course on the property, and not just a excuse holes that were constructed for somebody to practice golf. We have a full commercial golf course, multiple bridges, massive construction. PIR was done in the process, it was denied. The question is the golf course allowed to physically remain on the property in an AP zone under the current ordinance? It's a simple question. Now, it will appear to be simple because your ordinances are all written in terms of the physical object, and that's basically how land use is designed. It is not designed on the fact that somebody's out there swinging a golf club on a cow pasture. Nobody comes along with sirens and says, wait a minute, you can't swing that golf club out there. That's a far different scenario than somebody having constructed a full-size 18-course golf course in his backyard and saying, well, I'm not playing it. And the reasons for that distinction are important. First, if you allow the construction of a golf course in the AP zone, allow it to exist, you're basically saying that all of the activities that took place up to this moment today can happen again tomorrow in an AP zone in Calaveras County. There's nothing anybody can do to stop it. And I don't think we really want to relive that process again. On an AP zone land, you're allowed to construct in Calaveras County on agricultural land, and you don't have to go to these other agencies ahead of time. You're taking an action that's extremely inconsistent with the way land use planning is handled at every other level, from the state level to the federal level. You're coming in saying, you can construct possibly, I don't know, wait a second, I made that detour last time I read it, but you can basically come in and say, you don't have to make those kind of considerations to construct. Secondly, you're going to be facing the issue again as the golf course gets turned on and turned off. What do I mean? In the letter by the Central Sierra Environmental Resources Agency, they gave a good example. Is Pebble Beach no longer a golf course when the gates are closed and it's not open for play? The answer is no. Pebble Beach is always a golf course, and it will remain a golf course even if it was shut down for an emergency, an adjoining fire, any other type of issue. It's still a golf course. And we go back to the fact that land use is based on the physical existence of the structure, not to the fact that golf has to be played. If you have to say, gosh, this is not really my basic example I started with, this is not really a building, it's just a pile of lumber, because I'm not going to be using it. At night, it's not, nobody's in it, therefore it's not a building. And this is kind of a ridiculous, again, legal argument. So that's basically our position. It's a very simple position, and it's consistent with land use law. It's consistent with what your previous decision. You can't make the finding that if an object isn't used, it doesn't really exist for what it is. And this is an extreme example, fortunately. It's not a relatively borderline case. It's an extreme example of a commercial facility that was constructed as a commercial facility, being operated as a commercial facility, in an inappropriate zone, and you have to make that decision. So we're asking that. And the other issue was that staff said it's a moot point. It's not really a moot point. It may be moot to the extent the golf course is shut down, but as long as that golf course exists out there, there's the possibility the key gets turned again and people are playing golf the next day. As long as the golf course is out there, the environmental impacts caused by that golf course course still exists. As long as that golf course is out there, it exists in an AP zone, which is a violation of your ordinances. And to that extent, it is not a moot point, any more than an illegal garage is moot and no longer an issue simply because people said you're not going to park a car in it. It's still an illegal structure. So it seems like a very simple position, and that is what you're advocating for the grant or appeals to clarify that issue. If in fact that staff has indicated that this is not really inconsistent with their position, we ask you to clarify that. Thank you.
Members of the public, comments on this appeal? No? Now we are hearing both appeal number 2 and number 3. Comments on either?
Hi, me again. I just wanted to make a quick comment. Obviously, we opposed this appeal. It's a little bit unclear to me what ultimate result the appeal seeks besides clarification. I mean, to the extent that the appeal seeks to have the golf course physically torn out, the grass, the dirt, or whatever physically torn out, there's some important distinctions that needs to be considered. As Mr. Connolly said, land use has to do with the physical structure. And the difference, obviously, here is there's not a structure. I mean, that dirt and sand and grass and water is not in and of itself a structure. And so there is a difference there. In addition, as staff has sort of pointed out in both the original letter and the staff report, they sort of refer to the issue as being new. I'll also just note finally that the environmental agencies have said that the impacts of tearing the course out would far exceed the impacts of having it remain there.
I have a question for you on that.
Sure.
The idea of landscaping rings a little bit of a bell with me. I was wondering, do you feel that your client has or needs any kind of stream bed alteration permits when they change your water course at all? They're very attractive little streams running with all the little cobbles. They're pretty to look at, but is that a stream bed alteration issue?
Well, I guess I'll say two things. One is the landscaping term, as I understand it, originally came from the county staff, in which they said, yeah, I guess it's basically landscaping. On the stream bed alteration issue, DFG has been out more than once and has not had a problem in that regard.
Have they been there for that purpose?
Yes, they've been,
doesn't enforce stream bed alterations or anything like that.
DFG does enforce stream bed alterations, and so yes, that was part of the inspection purpose. Anybody else?
If you don't deny this and let him have the landscape, he's still going to have to water it. And it's going to take the water away from the water table. And like I said, I'm still going to have problems. And I've got livestock I have to have water. And also, every time I get up here to speak or something, the next night or something, I've had 3 incidents where my water has been cut around my property. And I've had to replace it. That's all I gotta say.
Thank you.
Let's get in 2 points. One, I think Ms. Osgood's County owns 5,000 acres. I'm not sure if you're going to find a piece of, possibly even a dowser could find water on a property. However, my primary point is, if you want to order that golf course be removed, first, I suspect a full PIR would have to be done for its removal. And secondly, are you going to designate exactly which department in the county is going to pay for its removal?
My name is Jack Neal again. again, I would just like to point out that as long as it's left as landscaping, it's permitting the almost daily golf activities out there. And that seems to be counter to what the decision that the board of supervisors has made and the decision that was made.
Anyone else? All right, Mr. Connolly, did you want to conclude?
I just want to clarify that the issue today is not how are we going to tear out the golf course or who will pay for the golf course being torn out or if the golf course is going to be torn out. The issue that was raised by the letter was the position that one golf course could be landscaping and it could therefore be allowed to exist under the AP zone as a golf course. And our response was on both the KIRC and both of the appellants was that that is not accurate because a golf course is not just landscaping. A golf course is an existing physical structure, as the EIR showed you, consisting of bridges, specific holes, tons of gravel, irrigation systems, designed for a specific purpose. So we're getting into kind of an abstract discussion. A golf course is much more than just landscaping, and it is specifically not allowed in the AP zone. And that is a simple determination that we are asking you to make today, or to clarify. As staff indicated, that may not be consistent with your staff's position, but we can't be in a position where it appears that there's an indication that a golf course can exist in an AP zone property. There was a raising of this, again, I just have to correct the record on some points. In terms of streambed alteration, Department of Fish and Game, no agency has given any clearance for streambed alteration in this case. This was clear through the EIR process. And the golf course was never given permission to be there at any stage, in any part of the record. So I just want to correct those pieces of revisionist history. But our position is that you're not making an order today to tear out the golf course. That's part of the only we're going. We're making a determination that it's not landscaping, that you cannot deprive yourself of the power to make that further order later on if it is necessary and has to happen, based on the fact that you found that it is landscaping and therefore allowed in the AP zone. We don't want to have you deprive yourselves of that additional authority. Thank you.
All right. Any public comments on Mr. Connolly's statements just now? If not, then we will close the meeting and bring it back to the commission for discussion.
I would like to have staff read through the recommendation that we'll be voting on.
Staff has recommended that the Planning Commission pass a resolution denying the appeal of both CSER and KIRC. As Mr. Connolly noted, this recommendation is based on Mr. Harrington's statement and considered in the context of the entire letter and specific to this project. And because of that, staff indicated that his references regarding use indicated that was the deciding factor on whether something was landscaping or actually constituted a facility or structure that was being used for a non-permitted use. This is somewhat at odds with what Mr. Connolly has presented to the Commission, so the Commission may want to look at this from that perspective instead. Based on the staff's perception of Mr. Harrington's statements, we felt that the appeals by both of the appellants were moot because the uses that have occurred over the previous months have dispelled any question of whether this is a private use golf holes or a commercial facility. And based on that, there is sufficient proof in the record that it is commercial activity. So I have to give it back to the Commission perhaps to consider it from that perspective as well.
Comment?
If we accept this appeal for these two different groups, there's nothing in there that says the golf course has to be destroyed, is there?
No, there is not. If there were any
So it's
action,
actually about whether or not it is in fact a golf course, not landscaping,
that's correct.
but depending upon how we vote, what if we vote that it is not landscaping? And it's a golf course. Can they still go out there next week and play golf and still make money while we're playing with the birds?
This would basically deal with the direction that code compliance, some of the actions that code compliance has already initiated. Those actions are based on the commercial use of the facility. They do not deal specifically with whether or not at some point in time in the past it was landscaping. Their decisions were based on the commercial use. So it probably, other than for future interpretation, would not have much effect on the code compliance action.
And can I clear, I mean, I think that we should probably do, act on these separately, which I think we are, because the Keeper Rural asks us only to sort of weigh in on if the golf course is landscaping, that's all. But the CSER has 2 points, and that's if the golf course is landscaping, but also 2, does the county have a legal obligation to initiate action to have us removed? I mean, that's another really large question. So maybe we should take, when we get to talking about it, take the easier one first, in the landscaping, just to suggest.
Well, I'm certainly a lot of mixed emotions about, a golf course not being used. What do you call it? You can call it a golf course that's not in use, just as easily as you can call it landscaping. I'm not sure that that's really relevant based on what has been occurring since the Board of Supervisors action. And I am prejudiced by the fact that the Namies have continued to use the property as a golf course. When I first read the letter from Brenda, I thought, oh, okay, I can buy that. But I really think the word is irrelevant to the problem that exists, which is that the Namies have not accepted the Board of Supervisors' decision and continue to pursue their business illegally. So I guess I would prefer to call it something else than landscaping.
Like a golf course?
I think the more pressing issue is the issue of, what does the county do now? And the county has an obligation to see that this illegal activity ceases. If further disrupting the property is the only avenue, which I hope it is not, but if it is the only avenue, then I guess that must be considered. But I don't think anyone wants to continue to disrupt and alter the state of the property. We just want to see that the illegal activity ceases and we have to pursue it. So I'm not hung up on what we call it. We still have the job to do, regardless of what we call it, halfway into a driveway or something. I don't know.
And, I don't think a golf course is landscaping. I do strongly believe that it has structural components, just as a bowling alley or a horse arena or a tennis complex, or even a more, gruesome thought of a gallows. A gallows is a gallows when we see it, even if, no one's hanging by the noose at the moment. But it's still a gallows and we know what it's used for. Also, I don't think the county would require that it needs to prepare an EIR on landscaping, so they must have prepared it on something other than landscaping, and that is structuring and the board of supervisors in denying the project. You know, in terms of, you know, environmental damage, or, you know, even just people traveling the roads to and from the facility.
Well, what I'd like to say is that when I took the tour of the golf course by one time ago, it was a very beautiful, nicely designed golf course. You'd be ashamed to see it disappear, but because it didn't follow what was needed to get it past the supervisors, it has become this controversial thing down there in glorious Wallace. And in my mind, it's very simple. Landscaping is what you do to make a golf course. If you have a hole out there in the grass part of the golf course, people drop light balls in the club golf course. And that's illegal under what the supervisors directed. And when as I had said before, when I read Fred Harrison's letter, I thought, well, at least there is a baseline. And things can happen to make this thing work one way or the other. And that didn't seem to take effect there. I would not personally like to see the golf course ripped out, but I realize that it is a nuisance and that people will want to golf on there. And that is, I think, why Brett, when he wrote the letter, public or private, to keep us in the county from deciding who belongs, who's the blood relative, or who's an adopted son or daughter, and they can play golf or not. I think that was a good idea. So I'm not too sure about the part of number 3 where they want the thing removed. That's sticks in my craw very badly, but it needs to be called what it is, and that is a golf course.
Well, I think it's landscaping either, it's a golf course. I mean, I've said that before. I don't know that we have the authority to tell them to rip it out, and we've already told them that they can't golf there. And we do have the authority to enforce the fact that they can't golf there. So I'm not exactly sure that approving these makes much sense. Actually, already made a decision in some ways.
My only thought on improving them is I think it just clarifies the statement about what, you know, like, if it looks like a duck and it quacks like a duck, it's probably a duck. You know, if it looks like a golf course, it's probably a golf course. If it looks like it's a tennis complex, it's probably a tennis complex, just in terms of, you know, clearly stating, you know, at least our position about, you know, you build a sports complex and then the landscaping may come in later and say, oh, by the way, I want a sports complex, but that's not going to fly the next time.
So you're in favor of granting that appeal?
Yes, I'm in favor of granting the appeal. Yes.
All right. Any other comments? Staff has read the recommendation. Is there a motion to deny appeal number 2?
Can I make that motion?
I'll second it.
And all in favor of the motion?
Before you move on, I think I'm confused on the motion. It sounded like the discussion was supporting the appeals to grant rather than deny. The staff recommendation is to deny.
Right.
So I just wanted clarification about what you were actually voting on.
So I'm going to approve the appeal.
Right.
Well, that's what I thought the motion was.
Yes.
You had made.
Yes.
So are you withdrawing your motion?
Yes, the other one. Look, I'm withdrawing that motion. My motion is to approve the appeal. Yes.
All right. Did you want to make another motion?
Oh, I just did. But I'll make a motion to approve the appeal.
Appeal number 2.
Number 2.
Which I'll second.
All in favor of the motion?
Aye.
All right.
And 4-1. And then with regard to appeal number 3, is there a motion to approve or deny?
I'll make a motion to
approve fails on a 3-2 vote. Is there a motion to deny appeal number 3?
I make a motion to deny 3.
Is there a second?
I'll second it.
All in favor of the motion?
Aye.
Opposed? No. The motion passes 3-2. And that concludes the discussion on that Next item on the agenda is an informational presentation by planning staff, project status update. Thank you for coming, everyone. We're still in the Excuse me, everyone. We are in session. If you'd like to discuss, please go out in the hall. Thank you.
Good morning. I guess it still is morning. Deborah Lewis, Planner 3. Back on June 4th, planning staff presented a project update report describing pending project applications that remain to be processed. At that time, we set a goal of completing a more comprehensive review of our project applications within 60 days and then bringing that new updated information back to you. And that's the purpose of the presentation today. To date, the Planning Department has received 33 project applications in calendar year 2009. This is down from our 10-year average of 148 applications per year and down from the maximum of 208 applications that we received in year 2004. Our 2009 project applications consist of conditional use permits, administrative use permits, zoning amendments, tentative parcel maps, variances, and accessory dwellings. We have received 3 requests for parking and landscaping review, and to date this year, we have received no applications for tentative subdivision tract maps. And our current numbers, in the same format that we presented them back in June, we basically have been considering a 10-year period in planning department history. Over that 10-year period and through today's date, we've received 1,480 project applications, and as of today, 165 project applications remain pending. Now, 80 of those 165 applications we have classified as pending other, which means they are awaiting revisions or they're awaiting supplemental data from the applicant. And while we do have at least one that I know of project application that dates to prior to 2001, essentially everything in our files that dates to 2005 and earlier is pending other, which means we don't currently have the information in hand to go forward with processing of those applications, which leaves us with roughly 85 project applications that are ripe to be processed and that are in process right now. Our pending other applications I had summarized for you before. Some of these are inconsistent with the goals, policies, and implementing measures of the general plan. Some of them contain fatal flaws. They lack legal access. They lack adequate level of service of the roadway, so on and so forth. Some of those other applications have been deemed incomplete, and we are waiting for revisions to the projects or supplemental information or additional baseline studies to be provided by the project applicant. This, in some cases, will allow us to deem the project complete. In other cases, this will allow us to complete an adequate CEQA review for those projects. Right now, we have 49 projects that are in the West County area and are affected by California tiger salamander and red-legged frog issues. But upon closer review of our project files, we've discovered that of these 49 projects, 32 of them are actually classified as pending other owing to issues that are not directly related to tiger salamander or red-legged frog. So while we do have a little bit of a project backlog in the West County area, there may really only be about 17 projects that we have adequate information on to take forward for processing, and those projects are in process right now as well. Now, we had also discussed our project processing action plan. There are a number of concurrent actions that we have been undertaking to address all of our pending project applications. Our first task was to identify all of the projects that had not yet been routed and route those immediately in chronological order. That task is substantially complete. For projects in the West County area affected by tiger salamander and red-legged frog, that portion of the project routing is in process, it's underway, but as we have a separate routing campaign to Fish and Wildlife Service, we are not as far along in routing the California tiger salamander projects. Our task 2 in our action plan was to identify all projects which could be or should be classified as pending other, and task 2 is substantially complete. We were able to present you with that number of 85 projects currently pending other and awaiting additional information. For each of those pending other projects, we are in the process of contacting each applicant. They each will be asked if they wish to continue processing the project. If so, they'll be given a list of additional information necessary to deem the application complete and allow the CEQA documentation to be prepared. They are going to be given a specific time frame that is typically 30 days in which to respond to the planning department. If the applicant does not provide a timely response in that interval and a schedule for providing the requested information, staff will take the project forward to the Planning Commission with a recommendation for denial without prejudice. We are not asking the applicant to provide all necessary information within the 30-day time frame. We're just asking them to give us a timeline within which they propose to do that. For project lands that are currently in foreclosure, the applicant is going to be notified that he has the option of withdrawing his project. If he does not withdraw, we will bring those projects before the Planning Commission for denial without prejudice. This task is ongoing. We have encountered a few projects in our files where the applicant has lost control of the lands and no longer has the right to implement the project. We anticipate, as we continue our review, we may find a few more projects where the lands are in foreclosure. For projects in tiger salamander habitat lands, we are currently expediting routing for 2 and 3 parcel splits, and then we are going to follow that with routing of the more complex, larger subdivision projects. That task is ongoing, but not yet complete. We are currently expediting our simple zoning amendments associated with boundary line adjustments and so forth, but that is ongoing. There are additional additional zoning amendments to be processed as well. Routing of all of our commercial projects is substantially complete, with the goal of expediting processing of all of our outstanding commercial projects. That task is ongoing. We're making good progress with that. We are expediting processing of 2 parcel splits and tentative parcel maps for smaller subdivisions. That task is ongoing. And we will continue to process variances, administrative use permits, and accessory dwelling permit applications as soon as they are submitted. We've always done this. 2009 project applications are in process according to this current processing timeline, and that task is ongoing. All of the projects that we currently have in hand are in process, our 2009 projects. We have successfully reinstituted regular weekly staff meetings to review all newly submitted projects as they come in. They are reviewed immediately for completeness. They are immediately assigned to a planner. They are routed within the first 30 days following submittal, with the goal of making a determination if they are ready to be processed or if additional information is needed. And our final goal is to return to the Planning Commission on a quarterly basis and provide ongoing updates of the status of each project.
One quick question on the commercial. How many commercial applications do we have that's on board?
We have 13 conditional use permit applications. Those are the ones most commonly associated with commercial projects. 9 planned developments, permit applications, but most of those are in association with either a use permit or a standard parcel map.
Thank you. Any questions? Good job. Any questions from the public? Okay, then we'll move forward to public comment period. 5 minutes per person. Anyone wish to speak on an item not on today's agenda?
Good afternoon, Colleen Platt with my Valley Springs platform. Just wanted to make this announcement for the benefit of the Planning Commission and anybody watching on Public Access TV. We're having a very important community meeting next week on the Valley Springs Community Plan. They will be talking about community area boundaries. They will be selecting boundaries, talking about what it means to be in a community plan, also looking at future population projections. So it's a pretty important meeting, and I wanted to pass that on to everybody and with some brochures.
Do you want to state the time, place?
That would be a good idea. Thank you for reminding me. It's next Thursday, August 27th. 6 o'clock to 8:30 p.m. at the Valley Springs Elementary School. And I believe the county will be having representatives there also, in addition to the COG and project partners and consultants and the public. So it should be a very informative meeting.
Thank you. Would anyone else like to address the commission? Commissioners, any comments before we adjourn? All right, we're adjourned.
Great job, Kevin.
I think we've got here.
That was a goal.
And we have a communication from county council that we need to return.